excited to talk about, striking that right balance between how to manage your HOA violations. I know over the past few months, we've been talking a lot about condominiums and the challenges that they have. So we thought it would only be fitting to start talking about HOAs because there's so much that goes on within our HOAs and many challenges that you board members and managers alike still have to deal with, especially when it comes to violations and getting these grievances resolved. So if you can hang in there just a bit, Emily will jump on and her and I will have an opportunity to discuss. And as I stated, Emily's here. So thank you so much, Emily, for joining us here. I was letting our audience know that, we've been talking so much about condos that we decided to do an HOA webinar to kind of, they have their challenges. So it's only fair that we provide some education on that side as well. So
right. Condos get all the attention.
Yeah, they do, really, right?
Especially in recent years.
Yeah, 100%. And it goes to show because we had such a significant amount of registrants to today's webinar. I would say the condo owners have gotten bored, but we got close to almost 400 people signed up for the webinar. So we're excited to be here today. So before we kick it off, Emily, sure, you're a little stressed. Let's let that out. If you could say a little bit about yourself and your firm, and then we'll go right into it.
Sure. So, yes, I don't know what we've heard so far, but my name's Emily Gannon. I'm one of the partners here at K. Bender Rembom. I've been with the firm, I think it's 12 years, going on 12 years. Wow. Been practicing for longer than that. I know, I'm sure you can't tell.
Nah, not at all.
Now, the firm is basically statewide. We are mostly concentrated down in South Florida. I'm in the Broward office. We have a Palm Beach Gardens office. We have Miami offices that are available for appointment. But we also have an Orlando office that just got a new attorney. So now we're up to 2 attorneys there. We have a Tampa office. So now we're pretty much almost everywhere. And again, just in, the advent of Zoom and all of that, forgetting all the technical problems we might have, we can basically help everyone across the state. So it's kind of nice. We represent primarily associations. This is all we do. We have a couple developer, issues sometimes, and sometimes some individual owners, but for the most part, we're representing the associations. So we're taking our instructions from the boards, obviously working with their management teams as well. But that's all we do. We have 22 attorneys, I think it is now.
Oh.
Almost half of them are board certified. I should be, but I'm not yet. I just haven't gotten around to taking the test. Don't get mad at me. Yeah, that's us. And like I said, this is all we do. So, we like to do these seminars. We like to, educate everybody because it makes our lives a lot easier. Why not? Right. So, yeah.
That's excellent. Well, thank you so much for that intro. I know we've done great work with your firm. So we're excited to always be working alongside you all when it comes to these webinars and providing additional education and whenever we're helping our individual clients. Yeah. As for myself, my name is Rafael Aquino. I'm the co-founder and CEO of Affinity Management Services. We are a community association management company. Our approach is pretty simple. We align to the board's vision. We help you execute that vision, and we deliver guaranteed results. We're proud to say we're the only company in the industry that provides guarantees for the services that we provide. But outside of that, I'm sure they want to learn a little bit more of how to deal with these difficult violations and HOA challenges. So let's start off with, I guess, some of the basics for our listeners. And Emily, if you could tell me a little bit about, define the word covenant. It gets used a lot, covenant conditions and restrictions. Maybe give our audience a little understanding of what it is and where they could find them in their documents.
Yeah, thanks, Rafael. Right. That's sort of the reason we're all here, right? Covenant enforcement. Well, let's start, like you said, start simple, start basic. What's a covenant? So main thing for everyone to know, and sort of the simplest, if we distill it down to the simplest possible definition, a covenant is basically a promise. So when you bought into your community, hopefully you were aware that you're moving into an HOA, which means there is a declaration that's recorded against the land that now binds your lot binds your parcel to certain covenants. And usually it is called a declaration of covenants and restrictions, or declaration of covenants and easements and restrictions, some variation of that sort of
Yeah.
title. Usually that word covenant is in there. So
Yeah.
I think it's become so commonplace we forget what it even is and what it means. But it essentially means that you've now promised to do certain things by living in this community. And the developer, when they put that together, basically promised that the association would also do certain things and basically provide you with certain services, potentially amenities, things like that. So that's the exchange. You've promised you're going to follow those covenants, and the community, the association, is going to provide you with, again, some amenities, some services, and is going to enforce those covenants. And that's
Yeah.
the big thing. That's what we're here to talk about. If you're on a board, that's your fiduciary duty. And I hate to tell you, because no one likes to be the bad guy, but if you're on a board, you have to be the bad guy sometimes. That's how it works. Somebody has to enforce it. And this isn't a situation where, we have to call the HOA police. It's the board. The board has to take that on, and they have to enforce all of these covenants. So, simplest example in a community is maybe, architectural restrictions,
Hmm.
pet restrictions, maybe you have lease restrictions, things like that, again, are written into your governing documents. So shouldn't be a surprise to anyone coming into the community. Those governing documents are recorded in the public records. So whenever you hear, and I'll give you, a little heads up, because we've heard it in the last couple of years, especially with more people moving into South Florida
Hmm.
that maybe come from an area that didn't have HOAs in the same way. We hear owners come in and say, well, it's my house and it's my property and you can't
Yeah.
tell me what to do. Well, actually, if you moved into an HOA, we
What?
can tell you what to do. And
Correct.
as a board member, it's our duty. We are supposed to be telling you what to do and supposed to be enforcing these things. So that's sort of the basic, premise here. And if you don't enforce your covenants, we run into issues.
Correct. Correct. And I can tell you from my experience, doing this for now 17 years from the management side. It's always that challenge. So we have challenges when we're coming into a new community and maybe the prior board didn't follow, what they should have, understanding that these covenants should be followed. Or in certain cases where, the board just gets a little bit selective on what should be and should not be followed. So
Oh, that's a
it's
key word you just used there.
yeah. So I'm happy you brought that up, that they have that responsibility. Sometimes it does feel overwhelming, but ultimately, to start enforcing those violations, or those covenants, I should say. But ultimately, it is their responsibility, because as soon as you start to get selective, that's where you start to find yourself in a different situation. And many times we forget, we talk about homeowners that move into a community and say, I never knew. But many homeowners, believe it or not, want to move into an HOA just because of, they want things to look a certain way. They want things to be manicured, for properties to be clean. And that makes it easier, because if you have an association, these are the colors. This is what the roof needs to look like.
Mhm.
And it doesn't work for all, but for many it does. And it's really just a fact of life here in South Florida. We don't see any change coming. If anything, what you're seeing now more than anything else is more associations. That way, the residents are bearing the cost of everything that's in there, and the cities don't have to. So you're seeing much more associations being built this way. I don't see any changes coming when it
Right.
comes to that. So speaking of that, why don't we talk a little bit about what happens if the board fails to properly enforce these restrictions? And I know it happens to us many times when we bring in new accounts where they haven't been enforced, and new board is ready. They want to change. What can they do to start enforcing as well?
Yeah. So, and I guess I should have pointed out too, to your point, Raphael, I mean, that yes, this is on the board to be enforcing these things, but also, you can lean on your management a little bit. Your
Yep.
management team should be helping you out with this.
Yep.
I don't want to say, you, Mr. Jones, have to go knock on Mr. Smith's door and say, hey, Bob, you're not supposed to paint your house, purple without getting approval of the ARC. You don't need to be doing that individually as a board member. Inform management, let management help you out. Management typically will be doing these, they'll go through the community, they'll look for these violations. Again, I know Affinity does a great job with that. They'll do these inspections, so they take a little bit of that burden off of you as a
Mhm.
board member. And also it is a little awkward, let's be realistic, when you have to go tell your neighbor, hey, you're not supposed to be doing that. That doesn't go over well. So maybe, again, let management take on a little bit of that, and management can send a notice and all of those things. Now, again, like Raphael said, if you come into a community that hasn't been properly doing it, or if you've just joined a board and you realize, wait a minute, we have these restrictions in our documents. They say you can't have commercial vehicles here. That's the easiest one to think about.
Correct.
And we won't get into sort of what's a definition of
Commercial, I know.
vehicle, and I know, and sometimes code takes it, and sometimes there's
That's
already
correct.
restrictions and we don't have to worry about it. But let's in a vacuum say you have a restriction. Article 10, subparagraph B says no commercial vehicles can be parked on a lot overnight. Now, and you move in, you've joined the board because you're all excited. I'm going to do this. I'm going to be on the board. Or in your case, you guys come into the community and you say, wait a minute, there's some commercial vehicles being parked on these lots. I mean, very clearly, no questions. They have signage, they have ladders. What's going on? We have this restriction. How come we're not enforcing it? And sometimes it is just a matter of, well, the old board felt bad. We don't, where are they supposed to go? We only have a 1-car garage. We felt bad. He couldn't fit it in there. We don't want him to park on the street, but whatever your reasons could be. Or it could just be simply the old board just didn't pay attention and didn't enforce anything. Sometimes we hear that too. And that's a little scary, but we kind of have to get you back on track. And I know, again, Affinity will help you guys out with this, but you need to be enforcing these things. So if you realize, wait a minute, we weren't enforcing, here are the issues you're going to run into. You could have a problem with, if you just sort of rattle off some new violation notices, to all the different addresses of where we see these commercial vehicles, you may get some responses that say, wait a minute, this commercial vehicle has been sitting in my driveway for a year. You've never said anything to me. I don't think you can enforce it now. Too bad, I'm going to leave it here. Or you may get a response from a different neighbor that says, wait a minute, that guy's had his truck in the driveway for years and you never bothered him. So why are you bothering me? These are all the scenarios that always come up, right? And like you said, we want to be careful when we say selective, because you're going to hear the two arguments. Either there was a waiver issue, which means basically as a board, you took too long to enforce it, or you didn't enforce it previously, and now you've waived the ability to enforce something. And usually sort of ballpark of that is if the violation's been there for about a year and you knew or should have known. And you can't just say, well, I'm new to the board, so I just found out. Well, no, if the truck has been in the driveway for, 18 months and no one ever said anything, you've now inherited that knowledge that the other board should have told you.
Yep.
And they didn't do anything about it. Or like you said, selective enforcement. That's the other one. And we hear that term thrown around, left and right all the time. Whenever you send violation notices, people will say, why are you picking on me? It's selective enforcement. But now selective enforcement, it has to be the same violation. So it can't just be, hey, you sent me a letter about my truck, but my neighbor walks his dog without his leash. Those two things are not at all related. So it has to be the same type of violation. But realistically, yeah, if you don't enforce against one owner, you're not going to be able to enforce against someone else. That's the problem you run into. So essentially, then, and I'm sure you guys, you'll have it. The board will come back and go, well, now what? Now we've lost the plot. We don't know what to do now. It's too late. Well, it's not too late. We can fix these things. We can sort of get you back on track. The way we do it, and this is an important term, I think, we say it's if you republish the covenant, or it's republication. You have a board meeting, you let everybody know, and it's decided at a board meeting, going forward, we're going to be enforcing, again, our commercial vehicle restriction. Send out a notice to the whole community as of whatever it is, March 1st, no commercial vehicles can be parked on lots overnight. But here's the catch, and everyone hates this term too. You have to let people be grandfathered in. So anyone who has already basically violated or is currently in violation, you have to give them a chance to register their violation with you. So, hey, I have a commercial vehicle. I've had this commercial vehicle for years. You never enforced against me. So basically, I get to keep my commercial vehicle, and you can enforce against everybody else. Any new vehicle that comes into the community after this new sort of deadline we've set, or new, line in the sand. But I get to keep mine. So you have to give them the opportunity to register that vehicle. Now they have to affirmatively do that. So if that you send out that notice and you tell everyone, if you have this violation, you need to let us know by the deadline. After that deadline, we're treating it as a new violation. So if you haven't registered, then you've sort of lost that privilege, so to speak.
Mhm.
And the other important thing about grandfathering that I think confuses a lot of people, it's that particular violation. So it does not mean that, Mr. Jones, who had that commercial vehicle or had that truck, it doesn't mean Mr. Jones gets to continue to violate everything. And it doesn't mean that Mr. Jones gets to buy new commercial vehicles or new trucks or, forever and ever and ever until the end of time. It means that vehicle that he has, maybe we're saying trucks, if he has a, 2020 black F-150, that is the vehicle he's registering. That's the vehicle that's grandfathered in. If he wants to get a new truck next year, it's not registered. It's not the one that we get to grandfather in. It would be treated as a new violation.
Yep.
That's important because a lot of communities will say, well, we had to grandfather him in, so he gets to, it's almost a free pass. He gets to do what he wants. That's not what it means, guys.
Yep.
Yeah.
I'm very happy that you brought that up, and what this goes to show is, the importance of involving the attorney when, if you're a new board and you're looking to do the right thing or do what your responsibilities are for the community association. Because I can't tell you how many times we come into a new account, and I get it, they want to go gun ho, and we say, hey, let's contact the attorney, because we would make similar recommendations that you would. But it's a couple hours of time for us to send a letter with the attorney's letter. Look, this is the direction that the board is looking to take. This is the steps that we're going to follow. And that way it gives a good sense to management and the board that this is the way we can do it. And this is how we're going to handle these situations. And as you mentioned earlier, yes, 100% management does help in putting together these processes. I mean, at least here we use a lot of technology to be able to make it easier and streamlined. Because many times boards that were either coming on and where they're new, they're sending violations just, you have to fix your grass, and they're not putting the actual covenant and where it's found in the documents. So that's one of the things that we make sure we do during the transition process.
And that's important because you'll get pushback from owners who say, well, wait a minute, what am I in violation of? Why are you telling me to do that? What am I doing wrong? And obviously, you need to tell them what it is. If you, like you said, if you're just saying, hey, you need to cut your grass, well, that's because, Article whatever 6 provides that you have to maintain your lawn and your lot has to be in good condition, or, let them know what the actual violation, what the provision is.
Correct.
And again, maybe there's a little bit of that it could be a little, legal jargon, so to speak, but,
Correct.
people want to know. And if you want to get them to comply, that's your best bet.
Correct. And the only way of getting people to comply, like, I say, even though some board members don't like when I say this, we're not in the game really to fine. I mean, if someone is being consistent and being abusive, then of course, when you're consistent as a board of directors and sending the violations, having a process, which is the most important part. Okay, what are we doing on the first notice? How many days are we giving them? Are we doing a second notice, or are we moving straight into grievance? Or do our documents really define the specific process? So that's why it's important that if you haven't done it, let's get the team together, get the attorney, management, the board together, and let's outline, okay, this is the process that's going to be followed. Because if you're using a tool that like we use at Affinity, a technology tool, we can just set those processes in and it's set it and forget it. And then the managers are just sending out the violations, and we can report back and we can make sure that we're being consistent in sending those notices. Because in our experience, what we have found is if you have a consistent grievance hearing and you're following your process, which we'll go into that in a little bit, you're going to get people doing what they need to do. And the community slowly will turn around. And one important point to Emily's is it's not just the vehicle. If someone sold their home and they put the wrong roof and a roof needs to be upgraded, that's where you need to make sure that, because we have seen it where we've come into communities where they've allowed aluminum roofs that are not permitted within the documents, but now the new board wants to fix it. Look, we can't do much now. We're gonna have to wait till that roof needs to be changed, and then we can enforce that. So, but let's keep going here. Emily, let's talk a little bit about what if a violation letter was sent and fined? Like, what can a board do? Can they suspend the rights, or what can they do once they've gone to the point of let's say fining, or maybe going to how they can fine, I guess.
Yeah, let's start there. So
Yeah, start there.
as you said, and I like your set it and forget it reference, and now
Yeah.
I'm immediately thrown back to various infomercials from my childhood, but which I appreciate. That's the thing, as you said, have a process to begin with. That's sort of the good start. Let's set up a policy, let's set up a process, a procedure, get with management. And right, if you need us involved, great, we'll help you out. But a lot of that probably you can logistically work with management on that. Get your violation notices. Again, when you're doing your inspections, you see that something's gone awry and there's a violation. Send the person the notice. Let them know. Take note too, if it's an owner that is not there. If there's if there's a lot that's being rented out. And maybe it's an issue with the tenants, who knows, or maybe it is something the owner would be responsible for. If it's an issue, like you said, maybe if the roof looks like it needs to be pressure cleaned or something like that. Send it to you're better off sending it to the lot and also sending it to the owner. So make sure, put as many people on notice as possible. There are tenants there, but we're going to send the notice to the owner because that's the person responsible.
Yep.
But also let's send it to the tenants because maybe if they're there, they're going to take care of the lot anyway. So, let's do both. Get the violation procedure sort of down. Send a couple, maybe it's just a gentle reminder.
Mm-hmm.
Then maybe it's not such a gentle reminder. Then we decide, okay, now are we going to fine, for example, like you said. The fining process it's not hard. The hardest part, honestly, is finding people to volunteer to do it, to be on the fining committee.
Correct.
Because again, as much as you guys on the board maybe don't want to be the bad guys, a neighbor generally doesn't want to be the bad guy and have to find their neighbors. And so that's the biggest complaint we hear about the fining process, is just that communities can't find people to volunteer because the fining committee can't have the board members on it, can't have family members of board members, can't be made of your management team, cannot be, all of these restrictions of who it can't be. And basically that just leaves, hey, do we have some, concerned members, owners in the community that'll volunteer their time? That's hard to get. We get it. Like I said, we get that question a lot, and I don't have a good answer for you. Essentially, unfortunately, I don't know if you guys have had more luck, Raphael. I don't know.
Yeah, I mean, this is the way I like to approach it, or we like to advise our clients. The committee's not there to argue with the resident. The committee is basically there just to listen. Well, the way I think the committee should approach it is, and this is where you would get, it is difficult to get volunteers. There's no secret sauce to it, except if you have a community that really wants to uphold the look and feel of the community. That's where you'll get much more volunteer. But if you're training the committee and letting them know, look, your goal is not to tell them this is what's wrong, this is what you did. No, look, this is the covenant. Here it is. This is what you're in violation of. Here are the pictures, 1, 2, 3. These are the dates of the pictures. Are you going to correct it? Yes or no? They say no. Okay, noted. And then at the end of the meeting, you take a decision as a committee. This is a democracy. And then you report back to the board of what your decisions are. You're not there to argue with the individual and say, you have to fix this now. If you fall into that trap, then, that's where the arguments and the rumors and everything starts going through. These are adults that signed up to live within these communities. So just keep it, as kosher as possible. Have
That's
as
a good
much,
way to think about it. Right. Just
have as
sort of
much
take it
information.
matter-of-factly.
Yeah, just matter-of-factly. That's it. I mean, listen, people are going to get emotional because we're all human. We all have our off and on switch. But ultimately, the idea is just to communicate and have the facts and the pictures. That's where technology helps, because instead of having the manager print all these notices, you could just pop up the screen, show, look, we sent you a violation on this date, sent you a violation on this date, and the day before the meeting, you should have a picture so that they don't give you the excuse, oh, I fixed it yesterday. And then you're like, okay, we'll check and then we'll get back to you. No, listen, this picture was from yesterday. Unless you fixed it last night, you're still in violation. We need you to fix it. So again, it's an opportunity to speak with with the members. Ultimately, they're your neighbors.
Right.
So I wouldn't take that position, just take the vote, give the decision to the board. If a
I
fine
like
is
that.
going
I
to be
like that,
placed, send the
that
letter.
way of thinking about it.
Yeah, I
Right.
mean, that's the way we try. A lot of people fall into the trap of wanting to go back and forth. But it's just not worth it. It's no different than board members at a meeting. Don't
Yeah.
fall in. The 2 minutes are for them to express how they feel. And then, you agree, disagree, or thank you for your comments, and you move on.
Right.
So that's the way we
Keep it
try to
simple.
approach it.
Yeah.
Yeah. So
It's,
so let me, I'm sorry, go
yeah.
ahead.
And if you are able to get a committee set up, good, which again, I like the sales pitch, the angle you have it. It is so essentially for the finding process, you have to give the owners an opportunity to be heard. Now, that's the language in the statute. And last year they clarified what that means because some communities took that to mean, okay, it's a 14-day notice for a hearing, but it's an opportunity to be heard. And we're going to look at that phrase and think, okay, so we'll give them the option because it's an opportunity and we'll present them with the opportunity to come to a hearing. But if they don't confirm that they want a hearing, we can skip that step. That used to be how some people viewed that portion of the statute. Last year, they clarified, the legislature came back and said, okay, wait a minute, that's not what we meant. We meant you have to have a hearing. So it's no longer this, we'll give the owner an option to come to a hearing and or to ask for a hearing. It's we are having a hearing. So it's a 14-day notice that you have to give to the owner that it's to come to the finding committee hearing or grievance committee hearing or whatever whatever we call it. And then, as you said, the hearing itself, it sounds maybe a little intimidating, but I think you can sort of treat it as more just a matter of fact event. Essentially, you're presenting some evidence, so to speak, and then basically the committee decides yay or nay. The
Correct.
board should initially make the determination in terms of the fine. Now, the fines, keep in mind, you're limited by statute. It's $100 per violation. You can do it on a continuing basis up to $1,000. But in the world of HOAs, you get an extra little perk here, guys. Condos can't do this. HOAs can. If your governing documents allow you to go over that $1,000, maximum, you can do it. So you might want to check your documents because you might want to be able to go over the $1,000. And if you have the $1,000 fine or more, if your governing documents allow, we can actually treat that amount like we would an assessment and we could lien for it if that language is in your governing documents. So that's something to look for. If you're thinking about, doing any amendments, that kind of thing, that's the best way to really give those fines some teeth. In the world of condominiums, they don't have that option. And everyone in the world of condos gets very frustrated because they say, well, we fined him and he's just not paying us. And what do we do? And what does that mean? And it's hard to collect and it's hard to really enforce. But in the world of HOAs, we can actually treat that as a lien and we can assess or treat it as an assessment and we could lien for it. And potentially you could foreclose over a fine, which may sound a little dramatic and a little
Yeah.
extreme. I get it. But that's the most, that's the strongest tool you have.
Of course.
So, but you have to follow the procedure in order to properly fine. So make sure you're, again, get with your management, make sure your notices are correct, make sure you've given the 14 days. And then I think, as Raphael said, maybe don't treat it as it's, so serious. It's just we're looking at the information, we're looking at the evidence, and then the finding committee's job is to just basically yay or nay. The
Yay or
board
nay.
thinks it's a $500 fine. They've presented us with 5 photographs of a continuing violation, and so we're going to confirm the fine, and now it's imposed. Then the other thing they added to the statute last year is they confirmed you're going to have to send a notice. And this, again, is sort of common sense in what we were doing anyway, but send a notice after the finding committee, letting the owner know that they've been fined and how the committee, what the committee's determination was, and let them know when that money is due. It's supposed to be 5 days after you've sent the notice. But ultimately, if you follow the procedure, like we said, and if you have that language in your documents that can allow you to assess and lien for it, could be a very significant tool. So
Correct.
it's a helpful thing.
Correct.
For sure.
Correct. Yeah, don't try to be Judge Judy is the way I like to say it. Yeah.
Right.
No
Right.
need for it. And being consistent with the violations, because we've come across where, oh, well, we'll do that one $25. It's just better. Everyone's $100 a day.
Right.
And if it's
Right.
in violation, it's been 10 days and here's the hearing, $1,000 is what you're going to be fined unless they say, look, I'll correct it in 30 days if I get it done. Our suggestion is, look, let's just get them fixed, because as residents see it get fixed, then they're going to know, okay, they're being serious. So I have a
Right.
great question here from one of our listeners, Edwin, and he has a situation where they have a violation. They can send a violation, and you have
Okay.
set for parking. You have 7 days to fix it. However, this person keeps getting the violation because they're in violation, but they fix it within the 7 days every single time. Is there anything that they can do to resolve this challenge?
That's the most frustrating thing. And I
Yep.
think at that point you really have to either you sort of reset your policy, so to
Yep.
speak, or it's, on the first violation, we'll give you 7 days to correct it. After that, and make it clear in your notice. If it occurs again after the 7 days, we're going to move forward and treat it as a violation. So you don't sort of restart every 7 days. It's you got your 7 days to fix it, but after that, now you're on notice that we're treating it as a violation. And that's it. I know it gets very frustrating, and the parking gets frustrating because people will, move their vehicle in overnight, and then they're still parked in the spot they're not supposed to be parked in the morning, and then they move it again, and you sort of play that game. But and not that I want to necessarily encourage this, but also, towing is a pretty big threat.
Yeah.
And I know I'm sure you guys get into that with any of the parking violations. That's
Mhm.
a big one too. Um, but that's a potential way to look at it as well. If you guys want to, talk to a tow company, if that's something you have in your community, they do have to comply with Florida statutes. You have to have certain signage in place. You have to have, certain things lined up before you can do it. But that's another serious threat. And obviously it happens usually more in condominiums, same kind of thing, just because parking tends to be a bigger issue in condos, but you can do it in HOA world too.
Yep.
Yeah.
Yeah, it's always the difficult. That's always the difficult. But I'm glad you mentioned about changing the dates and all that. Those are some great suggestions that could definitely be applied. So I have a very good question that I know comes up a lot with us when we're interviewing with new associations. And Paul asks, what happens if the management company is recommending to the board to enforce the restrictions, but the board doesn't want to?
Yeah, what do you do about that? And well, this is the thing. I think you have to tell them, hey guys, again, you have a fiduciary duty. If there's a reason they don't want to enforce, and sometimes that does come up. Sometimes we talk to board members and we say, hey, listen, I know I've told you 1,000 times it's your fiduciary duty and you should be enforcing, but here are all the reasons why this is actually a bad idea in this case, because maybe there was something where it was a selective enforcement argument or a waiver argument or whatever else we could sort of be up against. There could be times where maybe enforcing is not the best way to go.
Yeah.
For those, really only for those particular reasons, typically. But other than that, the board can't just be like, well, we don't think that's a big deal, or, well, we really like Mary. We don't care that she painted her house, neon pink. It's fine. Can't do that, guys. So, and management, it does put management in a very awkward
Very,
position. And I would
very.
remind them of those things. If we don't enforce in this one case or for this one restriction, now you potentially jeopardize enforcing against anybody in the future, or, for similar things and things like that. And now, I hate to use the term slippery slope because that's one of those legal things that gets thrown around a lot, but it's a bit of a slippery slope. Now you sort of lose track, and how do you get back on track, a couple years down the road? And now you have your owners complaining, wait a minute, why aren't we enforcing stuff? Why does the community look like this? I thought I didn't think I would have to live next to a neon pink house.
Yep, of course. I mean, from our side, it's exactly what you stated. It's really CYA also gets used a lot by you guys. It's making sure that we're notifying the board of what needs to get done. Again, I don't know if Paul's a board member or a manager, but if you're a board member, this is where you have a responsibility as well to, I'm sorry, if you're a resident and your board is doing this, this is where you have a responsibility as well to say, okay, well, this year I'm going to run for the election, or we need to make a change, because as a management company, we work on behalf of the board of directors. I know many times the media makes us look like something else that we're not, but we work on behalf of the board. So whatever direction they gave us, assuming it's legal, we will take that direction. When it comes to enforcement, if they don't want to enforce, there's not much that we would do outside of put them on notice stating, look, we do highly recommend that you do this because this could be the potential implications. But if you're a resident and you're seeing that, then I highly recommend you start considering potentially running for the board. If you're a manager, just make sure that you're putting them on notice. Look, I highly recommend, these are the reasons, and maybe show them some facts. Again, trying to take a different angle. Look at this home, look at this home. Imagine if this happened with 30% of the communities, what would it look like? Taking a different approach. One way or another, us managers, we're psychologists, so we have to know how to talk to our residents and our board members. So it's important to take that approach. I have a great question here from Denny that I know gets asked a lot. What happens if you don't have a fining committee?
All right. So there are some other options. Now, again, keep in mind, even if you fine and even if you suspend use rights or voting rights, which is what we can talk about for a second, ultimately, that doesn't necessarily mean that the violation got fixed or is getting fixed. So, you have all these tools sort of in your arsenal potentially, but we may end up, and we can sort of probably get to it towards the end of our chat here, but you may end up in litigation, getting the person to fix whatever it is, or to come into compliance and, fix or cure the violation. So one of the other things, in addition to fining, is suspending use rights, suspending access to amenities. If you're an HOA, maybe you have a really nice clubhouse, maybe there's a gym, and maybe you have a key card. Or my favorite is, honestly, and this sounds very silly because it's so simple, just your gate clicker or transponder or sticker or whatever we want to call it. If you make an owner stop at the gate and talk to the guard instead of being able to go through that resident lane, they get really mad about it. And I don't know why, but it seems to really get under their skin. I used to, and you can do it automatically if the owner's delinquent. That's sort of a separate thing, but you can also do it for an actual covenant violation. And you would have a committee, and it's very similar to the fining committee process, essentially. If they're delinquent, you can do it by board vote. It's a little different, but again, still an option. And I used to do some of our foreclosure work, and there was a guy who called here. He was sent to collections. He was sent, I think he may even made it maybe into foreclosure, maybe. Eventually he worked out a payment plan, but the whole reason he worked out a payment plan, he called and said, if his wife and teenage daughter have to continue to stop at the guard gate, he's going to end up divorced. So he needed to work something out because it drove them so crazy. So now, again, as a practical matter, if you don't have a gate, if you don't have a guard gate, that doesn't really necessarily help you, but that's your biggest, again, it sounds silly, but that's a big inconvenience for people. And if you can turn off, the key card or the fob or the transponder or the whatever it is to get into the clubhouse, if someone likes to use the gym, that also will drive them crazy. If you're a community where the pool's sort of open, you don't have those kinds of things. Again, I don't suggest that as a board member, you stand next to the pool with your clipboard and say, okay, well, let me look at my names. Oh, Mr. Jones, you can't come in here today. Your use rights have been suspended. Don't do that. But if you have the clicker, the transponder, the key card, whatever else that you could shut off, again, it does get people's attention. So maybe that'll be enough to sort of get them to go, what do I need to do? How do I get this turned back on? Now, important things to note. You can't shut off access altogether. So you have to make sure the person can get into the community. Like I said, the stopping at the guard versus going through the resident lane, that's fine. If you have one of those call boxes, sometimes you can do it, same thing. If their clicker doesn't work, but they can call in a number to let themselves in, that's okay too. You have to let them park. So you can't say, hey, now you have no parking and we'll tow you if we see your car in the community. Can't do that. A big one too, we get questions about, hey, we have bulk cable or bulk internet. Can we turn those things off? And that's sort of a little bit of a hot topic. The statute says you can't shut off utilities. Now, and then utilities is not really defined. Cable arguably is okay. I would lean toward, if you're able to do it, if there's a community that, is set up in a way where both cable and you could shut that off, maybe, okay, that's one way to go. I would not suggest that you shut off any internet or any phone, because that's much closer to a utility service. You
Correct.
could have, a security system that's synced up to a phone line or to an internet line. And if you shut that off for somebody, now you're exposing the association to possible liability. Or, maybe they have some sort of health issue, medical alert type thing. You do not want to shut those things off, because again, if you've now sort of interfered with any means of communication, you could definitely, be exposing the association to some liability. But in terms of suspending use rights, I would say transponder, key fob, key card, that's your best bet. Do you guys see that a lot, Raphael?
I agree with the transponder, the key fob, 100%. We've seen it work in the HOAs, especially with delinquencies, because that's where
Yeah.
we're very strict with it. The cable, we've had the question asked many times, and it's just way too sensitive for us. We always recommend against, and if they want to run with it,
Right.
speak with the attorney. Let's get the opinion first, because
Right.
you brought up some great points, which is what the way we see it is nowadays. Everyone's telephone is connected through internet one way or another. Last thing you want is an emergency phone call and they make a statement that, well, at home I use Wi-Fi and I didn't have Wi-Fi. So,
Right.
you
I
know,
mean, that's horrible. Could you
yeah,
imagine?
yeah, yeah,
I couldn't use my phone. I couldn't call for help. I couldn't,
yeah.
because the association shut it off for me.
That's correct. I think if you have a community that has these access controls, which are major benefits, then yeah, 100% go that route. It does become more challenging for us to deal with it, but it is what it is. At the end of the day, we're here to serve at the board's request. And if that's what we have to do to get people to correct their violations, and that's what we have to do. But
Yeah.
ultimately, as
And
Emily
if it's a
said,
home
it's
that has tenants,
yep,
that's another one. That's how you'll get the owner's attention, because that tenant
correct.
will be so mad that they
That
have
tenant
to,
will
same
not
thing,
deal with it.
that they have to, go through and stop at the guard or whatever it is. That's how you're going to get their attention. And if
Yeah,
they're delinquent, by the way, and technically, I mean, I know we're not really talking about collections issues today, but if they're delinquent, keep in mind, tenants, you can send a tenant rent demand to those
right.
tenants and put them on notice that, hey, your landlord slash the owner in this community is delinquent. You should be making your rent payments to us, tenant, please. And that's another option, just for you guys, in case you do have delinquency issues. If you're in a community where, those lots are being rented, that owner should be, that rent should be coming to you.
Yeah, that was one of the best statutes I passed. That really worked in 11 and 9 and 10. And yeah, so I do have a great question here that gets asked with regards to, let's say you put a violation on someone, $1,000, you did the maximum. Person comes out and says, okay, here's $1,000. Can you fine that individual again, assuming they did not correct the issue?
So this is the problem that we run into. Ultimately, that fining procedure and the suspending use rights and all that, it doesn't fix the underlying issue.
Yep.
It may not. It may get their attention and maybe they do come into compliance and they're scared of a fine and all that. But we've had owners who have done that, who have said, it's worth it to me. I'm not fixing it right now. I don't care. I'll give you $1,000. So, right, then it's a question of, do we sort of start the clock over again? Is it, the way the statute reads, you're limited to $1,000 for a violation, $100 a day, and then on a continuing basis. I think there's a way to sort of, and I don't want to get into sort of the details of it, but maybe kind of resetting the clock again, depending on how much time has elapsed and things like that. But that's ultimately, that's not going to get you necessarily where you want to be anyway. Because again, maybe that owner just doesn't care and will just keep issuing those $1,000 checks.
Yep.
But you still have, the neon pink house
Yeah.
or whatever it is. But how do we fix the neon pink house? So, you get to a point where all of these tools have been, exercised. Now what? And I've literally been at meetings or, various seminars, and I've even had a manager say to me, we tried everything. There's just nothing we can do. I'm like, wait, what do you mean there's
What
nothing
do you
we can
mean there's nothing? Yeah, yeah.
What do you mean?
Yeah, yeah.
So, and I'm like, wait a minute, are you in litigation with any of
Correct.
these people? And then they go, no, board doesn't want to do that. I'm like, well, again, we've sort of tried all of the steps. Now that leaves one avenue left, basically. So, for something like that, when we're talking about these violations, for the most part, now we've fined, we've suspended use rights, management has sent a million violation notices. You get to a point where it's okay, now we need to involve legal. We got to have legal involved. We got to send another notice. We have to tell them the next step is, legal action. Now, keep in mind in some of your documents, and you might want to take a look at this too, you may be able to get some of your attorney's fees back or your attorney's fees back prior to any litigation if you have the right language in your governing documents. Because I know that's a big thing too, that people don't want the attorneys involved sort of until it's, a last ditch effort, so to speak, because they're scared of the attorney's fees. Look at your governing documents. And for us to send a letter, the attorney's fees are not crazy. And if the person comes into compliance and they've gotten a little scared because they got a letter, with our letterhead on it, then it's worth it for you guys, probably. And that's just sort of a cost of doing business. But if you have the language in your governing documents, you might be able to hold that owner responsible for that letter anyway. But assuming we're going to have to proceed, you send them a pre-suit mediation demand, which again should come from your attorney, and you possibly have to go to mediation with these people and basically sit down at a table with a mediator, or I guess now it's all via Zoom, but sit down. It's a third party neutral mediator who's going to sit with you and basically go over the strengths of each side and hopefully try and get you to reach some sort of resolution. Now, in theory, if that doesn't work either, we could file a lawsuit, and the lawsuit is going to be something like a motion for injunctive relief, asking the court to issue an order to get, Mr. Jones to remove his truck from the community, or, to get Mr. Smith to paint his house because neon pink was not on our color chart. And we ask a judge to actually get involved and do that. And that language, if you have everything in your governing documents, you can enforce these things, and a judge should sign off on it in theory. And also you should be able to get your fees back. That will be part of the order. Mr. Jones, you have 60 days to submit a new ARC with the approved color panel, whatever it is. And by the way, you're also responsible for X dollars. Please pay it back to the board or to the association. So it shouldn't be that scary. So it's the same kind of thing of what you said before, when we were talking about the finding committee thing. It doesn't have to be this big scary event. I know litigation sounds scary. It is by nature unpredictable. We don't know how how judges are going to rule all the time. Sometimes they are human. They might be, cranky and not loving their HOA on that morning, but that's an option. And that's ultimately what you may have to do if you need to enforce a covenant and you've tried everything else.
Yep. And so we've spoken a lot about covenants, and why don't we talk a little bit about what a board can do? So let's say that you mentioned earlier that within HOAs, if you don't have a limit, then, sky's the limit. So why don't we talk a little bit about what an association or a board needs to do in order to amend those covenants or amend the documents?
Yeah, so look at, obviously, talk to management. They can probably give you a little heads up in terms of things that maybe you guys could change in your governing documents, because odds are you've been told through the years, or your legal counsel has told you, hey, if you had this language, you'd be able to do this. Or, hey, if we changed this language, we could do this. Kind of keep track of those comments through the years. And at some point, you're probably going to want to come back to legal and say, okay, we're ready to make some changes. Let's fix these things. Your governing documents are going to tell you what you need to do to get that amendment in place. Odds are it's something like, at a meeting, you're going to need whatever it is, a majority of the owners to sign off on the amendment. Or sometimes it's a higher number. Sometimes it's 75%. Sometimes it's 2/3. Those are not great. Sometimes that is very hard to get. So, maybe look at your documents first, talk to legal. And step one might be, let's do an amendment to amend the amendment provision to bring it down to a majority, or, whatever else. You may be able to do it through a written consent process, which is just basically a mail out. That makes it a little bit easier when we don't have to actually schedule a meeting, and you don't have to have people, you can always vote by proxy anyway, but if you do it with just a mail out and a consent form, sometimes that's a little bit easier.
Mm-hmm.
But all things that the board should consider in case they do want to either change some restrictions or, change the way you can enforce them. Get some extra teeth in your documents. You might as well.
Correct. Correct. Yeah. And I love the way you said it because that's the way we recommend it. First, let's get the easiest approved. And if that's a reduction, then let's start there.
Yes.
And that way you could do it in phases. Many times, boards, they want to move 100 miles an hour. And we're like, look, let's stage this out. What's the outcome? What's that? Again, when we talk vision, what's the vision of where you want to get to? And then based on our best practices, let's see how we can get there, working with the attorney. And then also the beauty, since we're here on an HOA webinar, is when you amend your documents, you're actually, correct me if I'm wrong, you're also recertifying the Murdoch compliance that you have, having
Oh,
to.
goodness.
Yes,
Oh,
so there
we
was
should
some
probably
recent.
touch on that maybe a little bit.
Yeah, there was some recent changes. If you amend your documents, now you're kind of recertifying them, and the attorney's gonna go through that as well. So you get a 2-for-1. And then you could do online voting as well and do it in stages. Again,
Yep.
as Emily stated, that would be the ideal way. Because last thing you want is just to give up. At the end of the day, a home is most people's largest investment.
Right.
And if you're moving into a community, it's because you want it to look good and you want to have that sense of pride of where you live, and where your family or whoever visits you. So it's important to stay on top of these things.
Yeah, yeah. It's and you brought up a couple of good points there. It's, and we don't want to get into it too much,
Yeah,
but
yeah.
but on your own, maybe Google market, well, just put market MRTA. Murdoch.
MRTA, yeah.
That'll be easier for you
Marketable,
guys to remember.
bookable, trust.
We
I
say
forgot the
Murdoch,
last. Yeah,
but
yeah,
yeah,
yeah.
Marketable Record Title Act.
Yeah, there
But
you go.
look that up real quick when you get off here. Bottom line, your covenants expire after 30 years.
Correct.
From the root of title. And there's a whole legal, jargon built in there. But the simplest way to think about it is your covenants might expire if your community is older than 30 years. You can preserve them if you're within that window. If you are outside that window, there's a different procedure to basically revitalize them and bring them back. So that's, again, another issue. If you had a community or a board that maybe didn't do anything for a while, your community is a little bit older, they didn't enforce anything, and now you're a new board or you got new management and you come in and go, okay, we got to enforce things. And then you look at the deck and say, well, wait a minute, I think it's expired. I don't know if we can enforce any of this stuff. And we may have that problem, and then you need to get legal involved to fix that and really evaluate that for you. But right, just starting with amendments, and we're sort of in the same boat. Like you said, we think big picture for our clients. We want to get you to your goal too. If you tell me we want to redo our documents and we have all these plans and we want to do all this stuff and add all this language in, listen, and I'll be candid with you guys. That's a lot of billing. It takes a lot of time on our end. It's a big project. I could gladly say, great, I'll jump right on it and I'll put that all together for you and I'll bill you all these hours for you. But realistically, if I see that you have a very high amendment threshold, I don't want you to waste your time and money and all of that. And if we don't think we can get it to pass ultimately. So maybe, again, even though I might, a lot of attorneys may say, great, good project, I can bill a lot. I'm going to tell you, wait a minute, let's backtrack for a second. Let's take a step. Let's fix that amendment first. I don't want you to waste your money if we're not going to get anything in place anyway. If we can't get the vote to pass, I don't want to draft a whole new, I don't want to spend all that time and incur all those fees for you if we can't get it in place. It just is a waste. And I wouldn't want to do that to my clients. So it's, let's start with sort of step one, get an amendment that we think can pass, hopefully, bringing that threshold down, and then go from there.
Correct. No, those are definitely great points, because again, we've seen in the 75% and 200 units, 300 units, most of the residents live at the property. Yeah. Possible, difficult, but possible. But when you're talking about, let's say 2,000 units and it's 75% vote, you pull, again, this is where we could help from management side. We can pull the data. Okay, how many tenants do we have?
Yeah.
We're 40% tenants. Okay, that means there's 40% of these homeowners are not at the property, and we can't do the grassroots approach that some communities do to be able to get to the numbers that they need to get to. Even if you have online voting, sometimes that'll be challenged, because I'm sure everyone would agree we all get a ton of spam mail, and sometimes they see these emails, they have no idea what they're there for. So
Yeah.
I have a great question here, and it looks like we have a board member that is from a newer community, and I know I've seen this before, where basically the developer never enforced any of the violations or any of the CCNRs, I should say, within the documents. Most of the owners were following them. New board comes in, they completely change the covenants, and now most of the residents are not within compliance. Are
Okay.
those old residents grandfathered in?
Well, it depends sort of how we're doing that too. So, we've talked about mostly restrictions that are in your declaration. There are also board made rules. Now, those do not have the same, level of authority, so to speak, as what's in your declaration, because the declaration is amended by typically your owners. Owners have voted on them, other than the ones that already were in place from the developer. But again, you were on notice that those were there when you bought. If we're talking about rules, potentially there's an issue with enforceability with rules if those rules don't comply with the declaration or if there's any conflict. So the easiest example we always give to people is, if there's no mention of vehicles anywhere in your declaration, no mention of a vehicle restriction, automobiles, trucks, anything like that, but a board decides we're going to adopt a rule that says no trucks. Now we might have an issue because technically if there was no restriction in the declaration about vehicles, the presumption is there is no vehicle restriction. And now by rule, if you're trying to adopt a vehicle restriction, that's a conflict. And that's the issue with the rule. The rules can't conflict with your declaration. So I'm not sure in this case, if we're saying that the new board maybe adopted some new rules, or if the new board actually amended and presented amendments to the community and actually changed the declaration, because those are different things. If we're changing rules, typically sort of the rule of thumb is those new rules will apply on a going forward basis. But anybody who didn't have that rule before is sort of by nature grandfathered in. Arguably, if you amend your declaration, and again, that goes out to the owners sign off on it, it's approved and all of that, and it's properly done. If you amend the declaration, depending on, again, how it's written, because sometimes you write the amendment to say it's only going to apply going forward. But if it's written in a way where it doesn't say that, arguably it could apply to everybody. And even if something was in effect previously, they may have to change that, or they may have to come into compliance with the new language. Just depends on sort of how it's all done.
Yeah, and this is why I know many times we get beat up, or why do we always have to contact the attorney? And we like to say, listen, we're professionals at managing things. We're not experts at
But you're
everything,
not lawyers. Yeah.
So we're not lawyers. And just for general knowledge for the board members there, we are restricted by statute, so we can't
I was going to
interpret.
say, and you'll get in trouble.
And we'll get in trouble. So that's why we make the recommendations. And ultimately, at the end of the day, what we want is to have, we want to protect you just as much as we want to protect ourselves. So if we have something in writing from Emily and from her team, then it makes it much easier for us to make decisions, and also for us to do the representation to the members at a board meeting of why we're taking these certain decisions. It makes it much easier to know, listen, you're not going to ask a plumber to help you fix a roof. So you're going to ask a roofer to help you fix a roof. So it's no different that if we're going to make amendments or we need to make changes, we need to become a little bit sterner with a particular resident, we need to work with the attorney. And that's why it's just as equally as important to have, something set aside in your budget for these kinds of situations. And that way you don't feel uncomfortable of having to contact the attorney. Because many times in my experience, speaking with my regionals and my team, it's not that expensive based on if you didn't do something and you find yourself in a lawsuit down the line.
Right. You're going to shoot yourselves in the foot and spend more labor anyway.
Correct. The way I like to, my regionals tell the board members, like, okay, would you rather pay a $5,000 to $10,000 deductible or pay the attorney $600 to get this done and us to be sure of what we did? Right. So not including the time of the manager dealing with the lawsuit, and I can go on forever about that. But so I do have, I guess, one more question since we were a little bit late. We'll extend an extra 3 or 4 minutes. I have a question here from someone that says, so let's say a homeowner's in violation. They have a dead tree that needed to be fixed. I'm assuming this tree is small. Board decides to remove the tree and put in a new tree. Do they have the right to be able to do those kinds of things?
Well, I'm actually glad you asked that question, because it does hit on a sort of a newish hot topic, so to speak, that I wasn't sure we'd have time for. So great. Okay. Self-help. This is now a new potential issue for you guys. In theory, it sounds great. In theory, hey, if you're not doing something you're supposed to do, owner, the association can step in and do that thing, can maintain your yard or whatever it is. And even if the language provides, we can charge you back for the cost of what we had to do. A lot of documents have language like that. And if they do, that is the authority that you have. You have the authority as the board or as the association to take the action and do it. Now be aware, sometimes that language is not in there. So it does not mean you just get to do it. You have to check your documents. And sometimes there's language that specifically says, after a 30-day notice to the owner
Correct.
of whatever the item is that needs repairing, the board will, or the association can do the repair or whatever it is. So yes, in a vacuum, you might be able to do that, to remove the dead tree and whatever it is. But you have to check your documents. And the other part of this has now gotten a little bit more complicated. We used to tell boards, for the most part, if it's a maintenance issue and it's something like, maybe a dead tree or trimming the grass, that's easy enough. You could probably send your landscapers out, take care of it. Won't be a big deal. But what if the maintenance item is, hey, you need to pressure wash your roof or you need to paint the house?
Mm-hmm.
That's a big
Yep.
take. The association doesn't want to have to go, I'm gonna go ahead and replace that guy's roof because he's not doing it. We used to tell everybody, bring legal in, and hopefully through legal action, we can get a judge to say, Mr. Jones, you have to replace your roof, or Mr. Jones, you have to, paint your house or whatever it is for those sort of big ticket items. We don't want the board having to do that. And the association doesn't want to take on a project. And and then is the association taking out a permit to do this? And on behalf of the owner, it sort of doesn't make a lot of sense. When we're talking about something small, it does, but not when we're talking about something big. The problem is there were some cases that came down last year that basically sort of impaired this a little bit. Because again, the legal relief was injunctive relief. We go to a court and say, we need the judge to issue an order to tell Mr. Jones to do X, Y, Z. But as part of getting injunctive relief, you have to be able to show that there's no other remedy available at law. It's a whole legal argument. With some of those cases in HOAs that had language like that, the judges looked at it and said, well, wait a minute. You do have another option. You, the association, can go and do that repair. So why don't you try and do that first before you come to me? Which was not the way we wanted that to come out.
Wow.
Now that complicates things. So we want to make sure. So now there's a whole issue about self-help and whether you do want that language in your documents or maybe you don't. And not to promote our website too much, but there's a specific article in there about this just recently. If you go to kbrlegal.com, and you can read about it in more detail, because it is sort of now it's thrown a little bit of a wrench in how we're proceeding with these things. So maybe now we don't want that language in our governing documents, or if you do have it in your governing documents, that may change how you have to treat that violation, where you have to be prepared to say, hey, we're going to do this repair for you if you don't, basically.
Mm-hmm.
Whereas again, maybe that's something the board wouldn't otherwise want to do. So it's a bit of a hot topic. I would talk to legal before you do anything like that.
Yeah, 100%, because you're opening up Pandora's box as well. If you start fixing something, then you don't fix the other. And in our experience, I don't know many associations that have such excess funds to be even able to put a brand new roof for someone. So,
and
but yeah,
always,
that's very interesting that the judge took that angle. I'm sure you were. I'm totally surprised.
Not good at all. And because again, there's the possible liability, even if we're talking about just cutting someone's grass. Hey, the landscape guy, knocked into a rock and it scratched my Mercedes, and now association, I think you owe me, $20,000 to repaint my car.
Wow.
Things like that. You don't want to have to deal with that. It's much easier to say, let's go to court and have the judge tell the guy he has to do his repairs. But now we've gotten this a little bit more complicated in the last year or so. So.
Of course, I can imagine. Well, coming up on that hour, I want to be respectful of your time and those of our listeners. It looks like we're going to need to schedule another one because we didn't even go
Right?
into the details of architectural and how that impacts.
No.
But
Make
as
sure you
we,
have guidelines.
yeah.
That's my parting word for you.
So as we wrap up, I guess maybe if you want to give how they can reach you, I'm going to pop something up with our contact information, but how they can reach you and any final takeaways.
Sure. Thanks, Raphael. Well, like I said, we have a website that has additional information, some articles that might interest you. And it's just kbrlegal.com. My email, if you want to contact me, is just egannon@kbrlegal.com. Not related to the Palm Beach County tax collector. Sorry, but spelled the same way. EGANNON@kbrlegal.com.
Excellent. Well, thank you so much for joining us, Emily. A pleasure to have you on. As for myself, you can reach us at managedbyaffinity.com. It was great to have you all here. I wanted to applaud all the managers, residents, and board members that are here. It says a lot about your leadership and your commitment to your community. So we hope you join us in our next webinar. We are definitely going to have another one, Emily, because we had a great audience. We left maybe 40 plus questions, but
Oh, sorry, guys.
if you need to reach us, either of us, I'm sure both Emily and myself will do our best to be able to guide you and provide the information that's necessary. So thank you all, and we look forward to seeing you in our next webinar.
Thanks,
Bye-bye.
guys. Bye.